Morning, everyone. Thanks for joining. I'm Brittany Dennison with the Colorado Livestock Association. Just first and foremost, want to thank you all for coming and want to thank each of our partners who also gave this opportunity to their members to be able to attend today and listen to the update from Range Law, Colorado Cattlemen's Association, and Colorado Farm Bureau. Thank you both so much for partnering with us to bring this important information. We're going to go right ahead and jump on in this morning. Today's presentation is on Agriculture Employment Law Update, presented by Range PC attorneys Kevin Paul and Cindy Coleman. If you have any questions today, go ahead and wait till the very end of the webinar, and we will let you know what to do with those questions at that point. But with that, I'm going to go ahead and turn it right on over to the Range Law staff. Thank you guys so much.
Thanks, Brittany. It's nice to see everybody. We've got a lot to cover this morning, so we're just going to dive in without any introduction. Cindy and I are going to cover this morning quite a few issues that we are concerned about making sure that you're aware of with respect to the employment law and regulation that applies specifically to agricultural producers in Colorado. Let me make sure that we're going to get our slides working here. Cindy, can you see the slides okay?
I cannot see them yet, Kevin.
All right, coming up. It'll take me just a second to get the screen shared for you. And we'll get that done. How about now?
Yes, the slides are there.
Excellent. Okay. Give us just a second to make sure this all works all right. As per usual, the technology is a little bit of a challenge.
Best
Only once you go live.
Yeah. I'm just having a little trouble being able to advance the slides. Give us just a sec.
No worries.
Thank you. Okay, there we go. All right, one of the reasons we wanted to talk to you this morning is that we're dealing with an audit being conducted by the Colorado Department of Labor and Employment, and that involves an agricultural producer, in which we have been introduced to somebody that we didn't know about before. Her name's Molly Graver, and on the slide you'll see that her title is Agricultural Industry Enforcement Specialist. She works in the Division of Labor Standards and Statistics, and Molly heads up a team that has been appointed by the department specifically for the purpose of assuring that agricultural employers are complying with specifically wage and hour regulations, the minimum wage, overtime, and other things that the Department of Labor and Employment is responsible for. We had not seen this before, that the department had actually established a program, essentially, that focuses on enforcement of these regulations with respect to agricultural producers. That kind of was a wake-up call for us. Molly's a really nice person. We've done well working with her, and she understands the challenges that agricultural producers have in complying with the myriad regulations that apply here in Colorado. But she's also responsible for making sure that you're doing what you're supposed to do. And we wanted to make sure that you were aware that, in essence, the Department of Labor and Employment is kind of watching over your shoulder these days. We also took into account I'm not really sure why we're not working here. Hang on. There we go. A publication from the radio station, KUNC, public radio up in northern Colorado, together with Rocky Mountain PBS that was published just last month at the beginning of December that talked about the work that Colorado Legal Services and their migrant worker program focuses on specifically sheep herding and sheep herders and the efforts that the Colorado Legal Services Office is making specifically to go out and talk to folks in the field about whether they're being paid appropriately under our minimum wage and overtime regulations. I know that there are some of you on the phone on the call today who have bumped into somebody named Jennifer Rodriguez, who heads up that migrant worker program, and that's not always a pleasant interaction. Please recognize that Colorado Legal Services, though they don't have very much staff in the way of staff, is nonetheless very interested in assuring that workers in agriculture are being paid in accordance with our both minimum wage and overtime requirements, and also are being provided the breaks, that they are guaranteed the transportation to town that they are entitled to under our regulations and laws now. And again, it's just a matter of making sure that you're aware that folks are paying attention to agriculture now in ways that they haven't before. The bottom line is that most of what the Department of Labor and Employment and Colorado's Legal Services do, and they work together. They make no bones about that. They collaborate with each other. They work on the basis of complaints. And in essence, if somebody leaves your farm or ranch in a way that's not necessarily amicable, oftentimes they find their way to the Department of Labor and Employment or to Colorado Legal Services, and that is what generates an investigation where CDLE will send folks out, and Molly Graver is one of the people that you might see coming on to your farm or ranch and asking you about things like your payroll practices. One of the places that we have bumped into that we were kind of surprised about is that they care about posters. You are required as an agricultural employer to have certain posters in your break room, and also if you provide employee housing in the housing. One of our clients recently was visited by CDLE. They did not have the posters up that they were supposed to. They had posters up, but they were outdated, and they were presented with a fine of $45,000. Now, I don't want to overstate. Yes, they got a document that said you owe us $45,000, but we were able to help our client take care of that, and the department backed off as soon as we were sure that the right posters were up. But we want to make sure that you know not to put this aside. It's important that you have the right posters up in your break room. First of all, the agricultural labor rights and responsibilities poster, that needs to be in the break room and in your employee housing. If you have folks that are living on your farm or your ranch, you need to have a copy of this in every house that you provide to folks. You also need to have the Healthy Families and Workplaces Act poster that talks also about public health emergencies and whistleblowers. You need to have the 2025 comps order poster up. That has just been published on the CDLE website. And if you have an employee handbook that you give out to your employees and you ask them to sign off on, to acknowledge, you're also supposed to provide them with a copy of that poster and have them sign off on it. I know it sounds like a silly requirement, and it probably is, because people don't really read the posters. They're in very small type and they're not written terribly well, but you need to do this. And the Department of Labor and Employment is going to check up and make sure that you're doing it. Also, you need to have a payday notice up that tells people how often you pay them, whether it's once a month or a couple times a month. Uh, you need to have that poster up. It's important to have those posters up in both Spanish and in English if you have folks who speak Spanish primarily. One of the reasons the department pushes on us with respect to this is it's so very easy to comply. You don't have to buy these posters anywhere, and please do not do that. You'll get emails from companies that tell you that they'll provide these posters to you in a laminated fashion or something like that. Don't buy them. We had a client who did and had the posters that they purchased up, and they were out of date. It's very simple. You go to the Department of Labor and Employment website, which we have up for you here, cdle.colorado.gov, and you punch the button that says Labor Law and Stats at the top. That will take you to a page that says Labor Laws, Rules, and Resources on the left-hand side. You punch that button, and you'll go to a page that has posters on it. And you just punch that, and it'll take you right to the 4 posters that you have to have up that we just described for you. You print them on an 8.5 by 11 piece of paper, and you put them up in the break room. And particularly with respect to that one poster that's the Agricultural Labor Rights and Responsibilities Act poster, you have to put that in your employee housing. The payday poster that tells people when they get paid, the department doesn't have that up in Spanish yet, so you'll need to translate that for your folks who speak Spanish, but it's very short and it shouldn't really pose a problem for you. Please do this. I know it seems like a kind of a meaningless thing to have to do, but you don't want to get a $45,000 ticket from the state government. And it's an easy way to comply. And make sure that you check these out every once in a while when you have them up. Given that they're on a piece of paper, they can fade, they can get wet, they can fall down. So about once a quarter, check out and make sure you've got the right posters up. It's a really easy compliance issue. And as I said, it's a way to demonstrate to the department, if they do come on to conduct an audit, that you're paying attention to the compliance obligations that you have. Minimum wage, that has changed this year as of the first of the year. The Colorado minimum wage, which you know applies to your non-H-2A workers, and we're going to talk about H-2A issues in just a second, but for folks that are not H-2A employees, the minimum wage that you must pay to them is $14.81 an hour. That's increased from what it was in 2024. So make sure that you have changed with the time. And if you're paying folks minimum wage, that you're paying them at least that $14.81. And as I said, we'll talk about H-2A folks in a couple minutes because we've come across a number of instances in which it's apparent that folks who are participating in the H-2A program are not real clear on what the minimum wage is for H-2A workers, and it's not Colorado minimum wage. If anybody on the call is working in unincorporated Boulder County, that county has set its own minimum wage, and it is $16.57 an hour for 2025. That's the only county currently in Colorado that has set its own minimum wage, and we haven't heard about anybody else doing that. The city and county of Denver does. The city of Edgewater does. I'm not sure I've heard of any livestock operations in Edgewater, so I don't think you have to worry about that one. But if anybody's operating in Boulder County outside of the city of Boulder, it's $16.57 as a minimum wage. Minimum wage isn't much of a problem for folks. That's pretty easy to comply with, but overtime, that's a different matter. And we've been dealing with a number of issues for farms and ranches over the course of the past year, where folks are still having a difficult time complying with the overtime requirements. And it's not necessarily unexpected because our agricultural overtime regulations are a bit complicated. So we wanted to make sure and go over what those regulations are so that everybody's clear on what your obligations are during 2025. First of all, for this year, all non-highly seasonal employers, and we'll talk about what highly seasonal is. I would be very surprised if any of the folks who are on this call are highly seasonal employers. But if you are, there's a different rule for you. But non-highly seasonal employers like dairy farms and cattle ranches, this year, the threshold for overtime is 48 hours in a work week. It's not 60 anymore, where we started at. It's not 54, where we were last year. This year, it's 48 hours. And this is the threshold that, at least under the current statute and regulations, is supposed to be the threshold going forward. It won't change again. Please make sure that you have altered your overtime calculations, your threshold for paying overtime to your employees to 48 hours from where it was last year. We've had to work with folks who weren't sure about what that threshold was. And the Department of Labor and Employment, if they come in and audit you, will definitely pay attention to this issue. So make sure that if folks are working over 48 hours in a week, and remember, overtime is based on a work week. It doesn't matter what your pay period is, whether you pay folks every 2 weeks or you pay folks every month, you calculate overtime on a weekly basis, 7 days. And if somebody works over 48 hours in those 7 days, then you're going to owe them time and a half for the hours over 48 that they put in. Please don't get tripped up by this. Sometimes employers will say, well, if we pay everybody every 2 weeks, and one week somebody worked 50 hours, but the next week they only worked 30 hours, so that's 40, so that's 80, and we split it in two, and that's 40, so they didn't work any overtime. That does not work. You have to calculate overtime based on a work week of 7 days. And if somebody works over that 48 hours in 7 days during 2025 and going forward, that's when they're going to trigger the overtime obligation. For highly seasonal employers, that's this special rule that we have in Colorado that says if your farm works in a way where you double your workforce, at least double your workforce, for up to 22 weeks in a year. So for either planting or harvest times, you bring on a bunch of extra folks, then you have the 48-hour threshold, except for up to those 22 weeks when you've doubled your workforce, and then you can use a 56-hour threshold for overtime pay. We're going to assume this morning that those of you who might fall into that category are already good to go with what the rules are, because they haven't changed since they came into effect, and they're not going to change going forward. If you have any questions about whether you're a highly seasonal employer or how you calculate overtime, we're going to ask you to send us an email or put a question in the chat that Brittany can send to us, because it gets a little technical with respect to the rules as they apply to highly seasonal folks. And we don't want to get bogged down in that. But that rule does not change for 2025, and it doesn't change going forward. It's the same as it has been, with 48 hours during the part of the year where you don't double your workforce, and 56 hours as the threshold for overtime for that part of the year where you've got a much bigger workforce working on your farm. Okay, long day.
I'll take over for here, Kevin. I'll
Jump
give
in.
you a break.
That sounds good. Thank you.
So we were just talking about weekly overtime. That's not the only type of overtime that applies. You also, when an employee works more than 12 hours in a day, need to offer an additional 30-minute paid break on request. And it can be the next day if it was unexpected for the employee to work more than 12 hours. Now, should the employee get to 15 hours, once they're at 15 hours and 1 minute, we're into the next rule, which is you get an additional 1 hour of Colorado minimum wage. So once they get to over 15 hours in a day, it's the additional 30-minute paid break plus 1 hour at Colorado minimum wage. Now, if it's too complicated in your payroll system to pay someone just Colorado minimum wage and they're getting paid at least Colorado minimum wage, Molly Graver's never going to complain that you paid them the additional amount for 1 hour. Okay, now we've got more rules. So we have when it's more than 40 hours, not 48, 40 hours in a week, you owe them an extra 30-minute unpaid break. Again, this is something where it can just be tacked on to their lunch hour. If you're already providing 1 hour lunch hours, you're covered, but it's an additional 30-minute unpaid break. More than 60 hours, they get a 1 hour paid break. And then you add on top of that your extra 30-minute unpaid plus the 1 hour paid, you get to more than 70 hours. And now you've got the extra 30-minute unpaid, the 60-hour 1 hour paid break, and an additional 1 hour paid break. So if you have not been doing this, what you're going to do when you go back and correct is for anybody who's worked at more than 60 hours in the week, you're going to give them the 1 hour paid break. More than 70 hours in the week, you're going to give them 2 hours of additional pay for that week.
Yeah, this is something that we are finding that the department is beginning to pay attention to on audits when they come in, usually because somebody has complained that they're not getting paid correctly, and they do an audit of the entire payroll for a period of usually 2 years. And they want to see that you have records indicating that you have complied with these rules. We also have seen a couple of law firms in Denver that spend their time suing people over wage and hour issues. There's one law firm in particular called HKM that spends a lot of its time suing employers for not complying with overtime requirements. And we've seen the first of their cases against agricultural employers. They're beginning to realize that you have a lot of obligations to comply with, and it's hard to do that. And not everybody gets it right all the time. If you have not been complying with these rules that Cindy has described to you, it is our recommendation to you that you go back, you conduct a self-audit, and you correct the problem. You pay the employees that worked 60 hours and didn't get their 1 hour paid break. You simply write them a check and add to their pay. That will take care of a whole lot of grief that you will run into if either the Department of Labor and Employment or Colorado Legal Services or one of the law firms that's involved in suing employers because of wage and hour issues decides to pay attention to you. Now, the kind of tricky part of all this is that these rules may go away. There is a lawsuit in a case called Rangel versus Polis that is pending right now in Denver District Court. It has been filed by some of the farm worker advocacy organizations who are challenging the Colorado agricultural overtime rules, not because they're too complicated, but because their position is that folks who work on farms and ranches shouldn't be treated any differently than folks who work in the city and county of Denver at Taco Bell. And that overtime is overtime is overtime, and overtime has always been time and a half pay for anything beyond 40 hours in a work week. Right now, that case is kind of stuck. The parties have filed what's called motions for summary judgment, and they're awaiting a decision from the judge who is presiding over the case. It is entirely possible that the court will conclude that the overtime rules that have been put into place by the Department of Labor and Employment um, actually don't have a reasonable basis to treat folks who are working in agriculture differently from people who do other kinds of jobs, and enjoin those rules going forward. Whoever wins the case or whoever loses the case will certainly appeal the decision to the Colorado Court of Appeals, and it will almost certainly wind up in the Colorado Supreme Court one of these days. As you know, if you've ever been involved in litigation, it does not move fast. And so this is a case that could take years to resolve. But at some point, these rules may go away, which would mean that agricultural employers will be subject to the same rules as everybody else, and need to pay overtime at 40 hours in a work week. That's not the rule right now. As Cindy described to you, it's the threshold is 48 hours, and that's where it's going to stay unless the court does something different. And so you just keep an eye on this. And as always, working alongside the Livestock Association, we'll try to make sure that you know if there's any change in the overtime rules.
And Kevin, I wanted to circle back for a second to make sure we were clear on something.
Yep.
The overtime is paid at 1.5 times the rate. So that's the time greater than 48 hours. But the breaks are paid at either the employee's regular wage rate or Colorado minimum wage, if we're following. That is not paid at 1.5 times. Even though it's triggered by working more hours, it is just a regular pay break, not 1.5 times on the paid break.
Good point. Good point. We certainly sympathize with all of you because this stuff is complicated, and we have to go back and look at the rules every time we work with somebody. Please do your best to comply with this because, as we said, the Department of Labor and Employment now has folks who are particularly interested in and are assigned the task of making sure that agricultural employers are complying with this set of rules with respect to paying overtime to their employees. Now, some folks can be exempt from overtime. And Cindy, you want to go over the exceptions for us, please?
Sure. No problem. So just paying someone a salary is not enough on its own. You'll see there's 2 parts to this, but let's talk about salary to begin with. We're looking at the Colorado minimum wage here, not the federal minimum wage, Colorado minimum wage, because right now it's going to be a higher amount. So for 2025, that means the employee must be paid at least $1,086.25 each week, which works out to $56,485 per year. That is the minimum salary they must be paid. And their job duties have to fall into one of these 4 exceptions. The 3 traditional white collar exceptions: professionals, executives, and administrative. And then there's one specific agricultural one, the livestock decision-making manager. Professional would be if you hired a veterinarian to be your employee and to be on your ranch at all times. That person falls under professional, and that is a well-established exemption to overtime. An executive is someone who all the time manages at least 2 employees. They're going to be doing higher level managerial type tasks. Administrative is one that everyone thinks they fall into and they don't. With that, it's a specific level of decision making that you have to reach. So if you think someone falls into administrative, that might be something to reach out to an attorney, or it could be us or someone else, but just make sure that you've actually got the correct level of decision making, because that one's a tough one. Again, a livestock decision making manager, that applies only to agriculture. And I'm going to let Kevin explain that better than me, because he explains it very succinctly.
Well, first of all, this only applies to a livestock operation where the focus of the agricultural employer's business is raising livestock. If you're a crop farm and you have a cow or two, that's not gonna satisfy it. So if you're a dairy or you're a feedlot or you're a cattle ranch, this could apply to someone who is reporting directly to the owner of the farm or ranch, or is essentially the second in command, in a sense. Somebody who manages the operation, like a ranch manager who's responsible for the overall operation of the business. That person has to either directly supervise at least two full-time employees, or has to have responsibility for exercising judgment and making decisions about things that affect the entire business operation. They hire and fire people. They decide how much people get paid. They determine other things that affect the entire operation of a dairy, for instance. So if you've got somebody that you rely on to really run your farm or your dairy or your ranch for you, that person could fall into this category. And as long as they're paid $1,086.25 a week and a total of $56,485 a year for 2025, they may be exempt from overtime. That number changes every year from now on. It'll increase in concert with the consumer price index. So you have to pay attention to that once a year. We would suggest that if you intend to treat somebody as exempt from overtime, one of the most important things you need to have is a written job description for that person, so that it's clear that their jobs duties track those requirements that Cindy described, or that they fit into the livestock manager category. It's really, really, really important that you have written job descriptions for everybody that works on your farm or ranch, especially if you're going to treat them as overtime exempt, or if you have H-2A folks that are on your farm or ranch. And we're going to explain that in just a sec, like right
Well,
now.
Kevin, I would add to the job description, it's really important that it's accurate as well. It
Yes.
happens an awful lot that an aspirational job description is written and it doesn't match what the employee is actually doing. So just make sure those match.
Yeah. When the Department of Labor and Employment comes out to audit, they don't just look at your paperwork. They will talk to your employees and they'll ask them what they do. And if the job description doesn't match what the employees say are their job duties, then you're going to have a problem on your hands. If you've been treating somebody as overtime exempt and they aren't really meeting one of those requirements, the professional or executive or administrative or livestock manager categories, then the problem is the department's going to ask you to go back probably 2 years and look at the circumstances in which they would be entitled to overtime. And that can get to be an expensive proposition. So you may want to get a little help with that. It's not a bad idea to have an attorney look over those job descriptions with you and make sure that they actually do satisfy the job duties requirements, as well as that salary threshold, so that you're sure that if you get audited, you're not going to have a problem. We're going to talk for just a second about a couple of H-2A issues, because we know that some of you on the call do participate in the H-2A program. We also are advised that some of you are considering participating in the H-2A program as our country's immigration policies are likely to change going forward. The H-2A program is not a simple one to be involved with. It has substantial compliance requirements, and they're not all intuitive. You really do have to take a look at the rules and requirements, and you have to comply with them. Remember that the H-2A program it's a joint program that involves both the federal government through the U.S. Department of Labor and the state government through the Colorado Department of Labor and Employment, which is what's called the State Workforce Agency, that is responsible sort of on the ground for assuring that H-2A folks are treated appropriately, paid appropriately, and that the employers who bring them into this country through an H-2A visa are complying with the requirements that the federal program has in place. One of the most important requirements is that H-2A employees have to be paid the highest compensation that they are entitled to. And in Colorado, that is going to be what's called the adverse effect wage rate, the AEWR. The AEWR is higher than Colorado minimum wage. It is not sufficient for an employer who has H-2A employees working on their farm or ranch to pay Colorado minimum wage. They have to be paid the AEWR, which is higher. In 2024, it was 1663 through December 15th. On December 16th, the AEWR was increased to $17.84. The date is a little difficult to explain why they would change at December 16th instead of January 1st, but that's what happened. And so the Colorado AEWR for H-2A folks is $17.84 now. And that includes the last payroll for most folks of December. Please make sure that if you have H-2A workers on your farm or ranch, that you're paying them at least the AEWR and not relying on Colorado minimum wage. And we say this because we've seen some applications, what are called the job order, the ETA 790 and 790A that goes to the U.S. Department of Labor to get permission to bring H-2A folks into the United States. We've seen some of those that refer to complying with our Colorado comps order, that minimum pay standard that changes every year and that sets the minimum wage. And folks have made the mistake of thinking that it's okay to pay Colorado minimum wage. And the Department of Labor and Employment takes issue with that and will check up on you and make sure that you're paying your H-2A folks the AEWR, the adverse effect wage rate, which is higher. Also make sure that you are paying your H-2A folks in accordance with our overtime rule. It applies to them. As long as they're not range workers, we're talking about non-range employees who are paid on an hourly basis or a shift basis or paid a salary. They are entitled to overtime, just like every other agricultural employee is. Range workers are different. We'll talk about that in a second. But if they're not range workers, if they're farm hands, make sure that the H-2A folks are getting overtime pay.
Okay, so Colorado overtime applies, but the federal payroll tax withholding does not. You do not withhold Social Security, you do not withhold Medicare, and you do not withhold federal income tax from H-2A worker pay.
We've seen a couple of instances where people made a mistake. And unfortunately, what that requires is that you go back, you total up the amounts that you withheld, and you pay that to the employee retroactively because they were not subject. H-2A folks are not subject to these federal requirements. This is a concept that we want to make sure folks participating in the H-2A program are familiar with. Because we've seen some confusion here. It's the concept of corresponding employment. Corresponding employment. You might remember from like high school algebra or maybe college mathematics, this thing called a Venn diagram, where a couple of sets overlap each other and there's an intersection where they meet with each other. That is not supposed to happen with respect to H-2A employees. The H-2A employees' job duties are supposed to be completely separate and distinct from the non-H-2A employees on your farm or ranch. If there is any overlap between the two, that is what is called corresponding employment. And what it results in is everybody who's involved in those job duties has to be paid the adverse effect wage rate, the AEWR, both the H-2A employees and the non-H-2A employees. And we found that there's confusion about how this rule works. We're dealing with an audit right now where the Division of Labor Standards and Statistics and the agricultural enforcement folks are really pushing on the fact that the H-2A folks on the farm were doing some of the same tasks as non-H-2A folks. And that means the non-H-2A employees are entitled not just to Colorado minimum wage, but to the AEWR. And what the government looks at is the job description in the ETA 790A, that job order that you file. It's like your application to participate in H-2A. And if that job description covers other employees on your farm that are not H-2A folks, that's going to create a problem. In that you're going to need to pay those other employees the AEWR, and under the federal regulations, all of the other H-2A requirements apply to those non-H-2A employees. And that gets to be a problem because things like housing at no cost, meals at no cost, transportation, things of that sort become required for non-H-2A folks. And particularly the AEWR wage rate is applicable to those employees who are doing even one, and that's what's hard about this. The project we're working on right now involves the Department of Labor and Employment taking the position that even if there's even one task, say your 790A says that the H-2A workers are going to be responsible for spreading manure on the field. Well, if you have non-H-2A workers who are also responsible for spreading manure on the fields, that means the non-H-2A folks are also entitled to the AEWR, not just the Colorado minimum wage. So please be careful. If you're participating in the H-2A program, please, please, please get some help with that work order when you're submitting it. An immigration lawyer can help you. You really need to make sure that you understand if you're going to have crossover jobs and job duties, that you're going to need to pay everybody at least that AEWR. And it also is another good reason for making sure that you have written job descriptions for everybody on the farm or ranch. I know that's not common among folks who work in agriculture, but because the Department of Labor and Employment is sort of increasing, not sort of, they are increasing the attention that they're paying to agricultural employers, it's really important, both for overtime exceptions and for this rule about corresponding employment, and for other rules as well, that you do draft up a job description for each of the positions that you hire people for. Range workers, Cindy?
So we keep saying range workers are different. They have a weekly salary of at least $606.56. However, if to keep your range worker busy, you assign them some ranch hand type jobs, you have them do something else so that they're performing non-range work, then you've triggered the AEWR and Colorado overtime. And if now you've got your range worker doing this ranch hand work And you have some non-H2A people also doing the ranch hand work, you could trigger that corresponding employment as well, leading those otherwise minimum wage workers to also have AEWR and Colorado overtime.
Yep. That KUNC article that we talked about at the opening this morning makes reference to the fact that Colorado Legal Services is interested in this issue and in making sure that people who are involved in corresponding employment are paid at that higher AEWR rate, and in assuring that when range workers who are brought to the country as H-2A employees completely lawfully to work on the range are assigned non-range tasks, that they are also getting paid at that higher hourly rate, and that they are entitled to Colorado overtime if they work more than the thresholds that we've described for you. It all gets pretty complex when you've got H-2A folks. And for those of you who are participating in that program or considering being part of that program, please make sure that you understand what the rules are. We've developed a set of policies and procedures, kind of a handbook for dealing with H-2A issues that we can talk about with you. There are other really good employment and immigration lawyers in Colorado that can also help you with this. Please pay attention to it. Some of the organizations and businesses that are not lawyers, but that sort of advertise their services to help with submitting H-2A applications are not entirely familiar with these rules and are not in a position to be able to advise you accurately. So take care if you're in the H-2A program, because it is monitored, and it's going to be monitored more closely by CDLE in consultation with Colorado Legal Services. And we want to make sure that you're in compliance and you don't wind up with a problem. Sort of a potpourri of issues, please make sure that you have time records and that they're accurate. It does not matter whether you pay people on the basis of a shift, whether you pay people a salary, whether you pay them hourly. You have to have time records and they have to be accurate. You can do them, there are a number of different ways you can keep time records for folks. ADP and Paychex and other payroll administrators have digital online applications for keeping time, where employees can clock in and clock out using their cell phones. You can have an old-fashioned time clock where people punch a time card. That's fine. You can have people handwrite their time. That's okay too, as long as it's accurate. One of the biggest problems we have is when somebody challenges the pay that you're providing to people and your overtime compliance, and you don't have time records. We are essentially out of the game at that point. You have to have them, and you should have them in a way that is accurate and that you can represent to the government if they come in and check on you, or to a plaintiff's lawyer. The employee will agree these are the actual hours that they worked. And please, if you pay people on a shift basis or on a salary basis, please don't be misled into believing that you don't have to have time cards. You do. It's really important, and audit them. We're dealing with a project right now where a payroll administrator's digital program rounded the time for employees that were checking in at like 4:50 in the morning for a 5 o'clock shift, as though they actually checked in at 5 o'clock. And the Department of Labor and Employment is making us go back and redo all of the time records so that they get paid for that extra 10 minutes. We suggest that you pull a few of your time records on a quarterly basis to make sure that they're accurate. Housing credits. We know that some of you take a credit for the housing that you provide to your employees in calculating your compliance with minimum wage. realize, please, that you don't get to decide how much that credit is. That is established by rule in Colorado. And the rule is the actual cost of operating the housing, or this is the number that applies to everybody, $100 a week if you're providing a house for a single employee, or $25 a week as a credit if the employee is essentially co-housing with other people. You have a house that has 4 bedrooms, you have 4 employees that are in that house. You can take $25 against the minimum wage for each of those employees. We've seen employers taking a lot more than $100 a week or $25 a week for folks to help cover the cost of housing. And that's just not permitted under the Colorado comps order. Meal credits, Cindy?
So for a meal credit, well, I was going to say with the housing, you have to have that in writing and it has to be voluntary. It can't be something where you
That's true.
require it.
Right.
Meal credit works the same way. You've got to have them voluntarily accept this. You can't require it. It has to be written down, put it in writing, and you can only do the reasonable cost of the meal without markup. There's no markup allowed on this.
Yeah, it's the grocery store price. And that writing it down is really important with respect to housing. We've consulted with employers who terminated an employee and then had trouble because the employee didn't want to leave the housing that they were occupying. It is much easier to deal with that problem if you have a written agreement with the employee that explains the terms and conditions under which they can occupy the property. And if you're going to take the credit, the housing credit, you have to put that in writing too. Otherwise, if you get audited, you have to pay that amount back to the employee. Employment policies you really need in place. First of all, an overtime pay policy so that the employees understand when they're going to be entitled to overtime.
It's complicated enough to explain. You better have it in writing.
Exactly. Colorado Family Program, the family leave program that you most of you pay into, and that all your employees pay into. It requires that you provide employees notice of that program. You can go to the Department of Labor and Employment. There's a family button on the website where you can get the notice that's required for you to provide your employees. We already talked about the Healthy Families and Workplaces Act paid sick leave policy that you need to have that explains to employees about the minimum 48 hours that they have available to them per year of paid sick leave. These need to be in English and in Spanish. The Department of Labor and Employment provides a number of these, but not all of them. You definitely need to have a heat injury and illness protection policy. The Department of Labor and Employment audits on this that tracks the rule regarding protection from heat-involved injuries and shade and water. A key service provider access policy regarding who comes onto the property and when they can come on. And we've talked about this before. Breaks. The department looks for a policy that explains to your employees when they get paid and unpaid breaks. A transportation policy. This is important. As we said earlier, Colorado Legal Services is going out onto the range and talking to sheep herders and cattle herders about whether they're getting taken to town or an offer to go to town every 3 weeks. You know that non-range workers are entitled to a trip to town once a week. Check your Colorado Livestock Association employment law guide that Cindy and Jane update every year, and it's updated for 2025 for information about how you put that policy together. It's really important that you have it. You need a record-keeping policy that explains how long you keep records, and for instance, what's on an employee's paycheck stub. We see employers that get in trouble all the time because they don't have all the information they're supposed to, like how much paid sick leave does the employee still have available to them. If you have a farming operation, you're supposed to have a weeding and thinning policy. That's that crazy rule about the short-handled hoe. And it's important to have policies regarding housing. If you provide housing to your employees, that makes it clear that they can have visitors in their employer provided housing. The Department of Labor and Employment, for them, that's a big deal. And we suggest that you have employees acknowledge in some kind of a document that they've gotten all these policies from you and that they understand them, especially the ones around transportation and visitors coming to your employer provided housing, that you don't prohibit them from having people come visit them that they want to have in the place that they live. We're going to finish with a couple of words about the changes that may occur because of the change in federal administrations. The circumstances with federal immigration law we know are likely to change, and we want you to be sure that you're thinking about how you're going to respond to them. This is a guy named Thomas Homan. He's been appointed by the administration to be the so-called border czar. He used to be the director of Immigration and Customs Enforcement, ICE, previously, and he has made some statements about mass deportations that he intends to oversee that could affect our agricultural workforce. Please, please, please do not slip in your obligation to make absolutely certain that you have a complete and accurate Form I-9 for everyone who works on your farm and ranch. In the current administration, there have not been raids on places of employment and mass audits of employers as there have been in the past. And we want to make sure that you're not slipping up in paying attention to the fact that you have to have a complete I-9 for everybody that is on your farm or ranch. And this is not a good time to fail to comply with that obligation. There is a big, bad federal statute called harboring. It is a criminal statute under federal law, and it prohibits providing employment to or housing to someone you know or have reason to believe is in the country unlawfully and is not eligible for employment. It is not something you want to mess with. And it simply requires that the best way to make sure that you are not ever accused of violating the statute is to comply with the I-9 requirement, to make sure you check the documents, to make sure that they appear genuine. That's your only job. You don't have to photocopy them, and that you complete the I-9 on time and accurately, and you hang on to it. The bottom line is, if you know somebody on your farm or ranch is not eligible for employment in the United States, is not here lawfully, you have to terminate their employment. No questions asked, period, end of story. The problem that is likely to come up beginning later this month is with people who are presently part of the DACA program, the deferred action with respect to childhood arrivals that protects people who came into the country with their parents, for instance, and were not documented, didn't have visas to protect their status here, but have been here for a long time, have been working or going to school, have complied with our laws, and presently have a work authorization. It is entirely possible that that program is going to be terminated, which means those folks will no longer have work authorization. And if that happens, and you know that that is how they are working in the United States, you're going to have to terminate their employment. And there's just no way around it. So please pay attention to this. We don't know how this is all going to pan out yet, but we have good reason to believe that the next administration is going to put in place a much more vigorous effort to deport people who are in our country without lawful status, no matter whether they work on farms and ranches or on construction sites in the city. The word that we have is everybody's in. We may see raids on employment, on employers' workplaces. Um, Years ago, we saw dairy farms, for instance, being the site of raids, and that may happen again. You may receive what's called a notice of inspection, which is the notice that you have to provide your I-9s to an auditor within 3 days. In times past, ICE would not mail those to people, they would hand deliver them. And so you may see folks with blue windbreakers with ICE on the back and big guns on their hip delivering to you a notice of inspection. If that happens, get some help with it. There are things you can do during that 3-day period to correct errors in your I-9s that can save you money because you get fined if your I-9s are not in order. If you get a thing instead called an immigration enforcement subpoena hand delivered to you, it's going to ask you for a whole lot more than your I-9s. That's where you do really need the help of an immigration lawyer or a lawyer that you work with to help you make sure that you know what it is you have to provide and the appropriate way to provide it. It is also a really good idea to think about and talk about with the folks who help you run your farm or ranch what you do if government folks wind up coming to visit your property with something like a notice of inspection or an immigration enforcement subpoena. Um, you want to have signs up, and those of you who have attended the talks that we've done for Dairy Farmers of America years ago, this is going to sound familiar to you. We need to have signs that direct visitors to the office. When people like me come onto a dairy farm or a ranch, we don't know anything about how it operates, and we wander around looking for where we're supposed to go. Put signs up that say all visitors must report to the office, and here's where it is. Direct them to it. ICE officers will oftentimes not know anything about an agricultural operation. They're from the city. Tell them where they're supposed to go. Scripted warnings. You want to make sure that if they want to talk to your workers, that they understand that they can't just go out to the milking barn, for instance, and tell everybody, stop working and come talk to us because it's going to hurt the cows. You need to have these messages already kind of worked up so that if people come onto the property from law enforcement, everybody doesn't go crazy. They know what they're supposed to do. A phone tree is very important. If you're not there as the owner of the property, the owner of the farm or ranch, you want the workers, your managers to know who they call first. And there should probably be a phone number for a lawyer near the top of that. There are rules that we have to comply with. When ICE comes onto the property, there are law enforcement officers. There are things that they can do, and there are things that they can't. And you want to make sure you've thought through that. And finally, you want to make sure that there is somebody among your staff that you've had a talk with about how to deal with this if you're not there, so that it doesn't come as a surprise, and that they feel comfortable that they can handle it, and that they are aware of what the rules are with respect to where law enforcement officers can go when they come onto the property if they don't have a warrant, for instance, and how best to deal with them. It's way better to think about this stuff ahead of time than to wait until it happens. I don't want to be hyperbolic about this and overstate, but we don't actually know what's going to happen. The folks who are going to take over the government in a couple of weeks have made some statements that sound pretty frightening. And I don't know that that's what's really going to happen, but I would suggest that you prepare so that if indeed folks come onto your farm or ranch and want to talk to workers, that you are prepared for that. With that, we will say that we really appreciate the opportunity to talk to you today. We will be glad to answer your questions because we had so much to talk about. We didn't have a chance to let you ask them, and Cindy didn't have a chance to sit on the chat and answer them. So please write to Brittany and Jane at CLA, and they will be glad to get your questions to us, and we'll do our very best to answer them for you. Please keep up the good work that you do. You do wonderful stuff for our communities, and we're really proud of the fact that we get to work alongside you. Take care.
Thanks so much, Kevin. Just a few things before you all head off of the call. Thank you all again for joining. We really appreciate you taking a few moments this morning to make sure that you hear all the important updates that are coming now that 2025 has arrived. Yeah, just to follow up with what Kevin said, if you have any questions off of today's presentation, make sure to send them to myself, which is B Dennison, Dennison at coloradolivestock.org. And then I will help facilitate getting any of those questions either answered by us here at CLA or send those to Kevin and Cindy if we can't answer them ourselves. But with that, thank you all again, and thank you to Cattlemen's Association and Farm Bureau for helping us put on this presentation today. We really appreciate it. And today's presentation, if you want to go back and refer to it at any point, will be on the Colorado Livestock Association YouTube channel following today's presentation. It'll probably be a little bit later today, but we will certainly send out information about when it is live. But with that, thank you all so much, and go ahead and send those questions on over to me whenever you get a chance. Thanks so much again, and thanks again, Kevin and Cindy. We really appreciate it.